Dear students, today we will learn a new module, fraud. So when a representation is made with an intention to force somebody to get into contract, it is called a fraud. So this will have legal consequences because this is not innocent, this is willful. Purposely they are giving that statement to induce the other party to enter into contract. So now let us see what are the essentials of fraud. So the first one is making a false suggestion. See, if you want to sell a house property, so you are telling that all good people are staying there or all reputed people are staying there. Some false suggestion, some known people are living here. So this is a good locality. There is electricity, water. If it's not correct, or if they got the occupation certificate, if it is not correct, it's a false statement because the buyer will take that decision seriously because occupation certificate is very important in Karnataka. Next is representation is a fact. Representation when you are giving, see celebrities also when they'll come and advertise about certain companies, certain products. So they are giving that statement. I am giving the verification. So this is it's good for you. It's good for your health. That products they are advertising. This drink will give you everlasting joy. All these things, no, when they're making some statements, they have to be very careful. So if they throw advertisements also, if they are representing something, that will consider it as a representation by the person who's giving that advertisement or by the company. So if it turns out to be false, then the celebrity who's giving the advertisement and the company will be asked to pay the fine. Then active concealment of fact is also fraud. Wrong information in the prospectus. See, to attract shareholders to invest in the company, the promoters usually what they will do, they will give false statements in the prospectus. So this is wrong because many shareholders, they have no idea about the company. They will rely on the statements given in the prospectus and on that basis, they will invest in the company. So active concealment of fact is also a fraud statement or a fraud. It is fraud. If a company has not declared dividend, but the prospectus says that company has declared dividend, or they are using known people as promoters of the company, if they are actually not the known, they are not the promoters. So all these things can be fraud in the case of giving wrong information in the prospectus. Now, a promise made without any intention of performing it. See, the company is telling that we have come out with a new product, from a semi-artificial or semi-automatic product to fully automatic. We have invented that we are going to do that. We are giving you special features. So that meaning a promise, but if they are not able to perform that, see, any company is giving a false promise that we are going to do that, so then it is also amounts to fraud. If a company is giving a false promise, that meaning or any promise, they should be able to perform it. Next is any act or omission which the law specifically declares to be fraudulent. See, if they are saying that our check, we know that check validity is only 3 months. And then if Securities and Exchange India Act or Monopolies Restrictive Trade Practices Act or Foreign Exchange Regulation Act, if they are giving a statement saying that we are not obliged to follow these rules and regulations, so then it's fraudulent statement, it's fraud. Any act or omission which the law specifically declares it to be fraudulent. When we are living in India, when we are dealing with the activities from India, then whatever rules and regulations, we have to follow that. Now, any other act fitted to deceive, that is meaning to cheat somebody. You are using somebody, a third person, to talk to that person to enter into contract, or you are giving them some offers to buy the products. Companies will give sometimes to promote the people to buy that product, or they are coming out with name. See, if Eureka Pops, if they are coming out with another product, another company, the competitor, they are giving with any similar name. These are all fraudulent activities done by the people. Now, the representation should be addressed to the party misled. So this is very important thing. If the party affected has to prove that he has relied on that statement, and based on that only he took the decision. So here there is an important case, Peake versus Gurney. This happened in 1873. So Mr. Peake bought shares from a shareholder, but instead of collecting information, what he did was he collected information, he collected a prospectus and he relied on the statements given in the prospectus. So, but the thing you have to remember is that Mr. Peake bought the shares from a shareholder, that is Mr. Gurney. Gurney bought the shares based on the information in the prospectus. So there is a difference. So Peak has no right to check the information in the prospectus, because why promoters are giving the prospectus is for the first shareholders, first applicants to rely on the whatever the statement. Actually, there was some wrong information in the prospectus. But when Mr. Peak is buying the shares, it's his duty to collect information from other sources. He cannot take the prospectus as the main document for collecting information about the company. So here, the case was not in favor of Mr. Peak, because he bought the share from a shareholder. So it is his duty to collect information from other sources and not from the prospectus, which is meant for the first allottees of the company's shares. Next is representation must induce the contract. You are giving some additional input, so that will force the company to invest or the person to invest. So that means you are telling that, see, if it's an online coaching, you are telling that my son got full marks, so that the average student's parent also will think that he may improve that. But if you are giving a wrong statement, my son got full marks, if it's not the correct marks, then you are inducing the other party that to enter into that coaching class or to join that coaching class. Sometimes people will do for commission. We know that how brokers will force a transaction. They will make so many statements to enter the parties to enter into contract, especially when they are NRIs. Then their time is limited. They want to buy a property. They want to invest some money. So the brokers will use so many statements to force them to enter into contract. It may not be correct, and the person will not get enough time to check the authenticity of the statements made by the broker. Then the party acting on the representation should have been deceived and suffered damage. See, if an NRI, non-resident Indian, bought an apartment, see, somebody has committed suicide in that. That meaning the broker will hide that fact from the NRI, and NRI has limited contacts in that city and he has no time to check the details. So whatever the broker is telling, he is relying on that statement. Imagine after registration he has come to know that somebody has committed suicide. If it's as per our practice, if somebody has committed suicide or anything bad, something bad happened in that apartment, nobody will buy that apartment. So here you have to remember that he got cheated. Yes, he got cheated, and the broker's statement was the information NRI got to invest in that property. So that meaning there is an element of fraud. Now what are the consequences of fraud? So consequences of fraud, the affected party can cancel the contract within the reasonable time. Now what is the reasonable time? Before a third party will enter into the same contract. Say for example, A is selling something to B. So if it's a fraudulent statement, if on the basis of fraudulent statement, before B sells that item to another party, C, A and B has to solve this issue, or they have to enter into, they have to see that they have to prove that fraud and they have to cancel the contract. Once B has sold that item to C, another third party is involved. So the case will become complicated. So that is why within the reasonable time, within that contract will pass to another person, they have to act. So that is the first thing. Then in the case of fraud, cancelling the contract is possible, but important thing is within the reasonable time. Now insist on the performance of the contract if the representation was true. So if you are telling that the coaching class is effective, the tutor is good. So that meaning if the tutor is changed, some new person is coming and teaching, students are not able to understand. So what the training institute can do is they can use experts to give that coaching class. So that meaning whatever the representation they have given, our experts are teaching. Teachers with so many years of experience are teaching. So insist on the performance of the contract if the representation was true. Next option is sue for damages. See, if the person has bought an apartment where they have committed a suicide, so or there is no electricity connection or water connection or no occupation certificate, but the broker has promised all this. So then after registration, the investor has come to know that these wrong statements made by the prospectus. So what he can do now? He can sue for damages. Now, whether silence is fraud. So you have to remember that as per section 17, subsection 2 of the Indian Contract Act 1872, active concealment of material fact is fraud. If somebody is asking for opinion, if you know something, it's your duty to give the correct information. But passive or non-disclosure is not fraud. If I don't want to give an opinion, I can always say that I am not ready to give the opinion. You can contact somebody else. Next, contracts of UBERRIMAE FIDEI. What are contracts of UBERRIMAE FIDEI? Contracts of utmost good faith. In certain transactions, you have to remember that you have to give the correct information. See, for example, in the case of insurance contract or you're entering into a partnership, it's your duty. We are going to list the transactions which are coming under UBERRIMAE FIDEI. So you have to remember that in these contracts of utmost good faith, both the parties should disclose all the known facts. So there should not be an element of fraud. Now, silence is fraud in this type of contracts. That is why these contracts are special. UBERRIMAE FIDEI. You have to disclose all the known facts. So 8 relationships are coming in the contracts of UBERRIMAE FIDEI. First is fiduciary relationship. In the case of trustee and beneficiary, a trust deed formed for the welfare of the orphans. So that meaning if it's HIV affected, only HIV affected children can come there. So the beneficiary should get the maximum benefit. There cannot be a person without HIV coming into that orphanage. Next is contracts of insurance. Your health condition, your family health history, any information you want to disclose, it's very important that you have to disclose to the insurance company when you're buying a product. Otherwise, it will not be possible to get the insurance compensation. Legal consequences will be there later. Then contracts of marriage engagement. You know that before marriage engagement will happen. That meaning both the parties, families discussed, the bride and the couple have discussed everything, then they're getting into marriage. They're giving an official commitment. So here you have to remember that all the known facts, any bad habits or anything like that, whatever the educational qualification, family background, the work, the salary, everything should be disclosed clearly. Otherwise, it will end up in divorce. Next is contracts to subscribe for shares in companies. So companies, when they are giving some information in the website or when they're giving some information in the prospectus, it should be correct. Contracts of family settlement. When they're settling the family property, that utmost good faith, because otherwise it will create problem with the siblings. Then contracts for the sale of immovable property. Immovable property, everybody will invest, huge investment is involved. So whatever the known facts, whatever the correct facts should be disclosed there. Then partnership contracts. Partnership contracts, they will always end up in dispute. That is what we have seen. So why? The partners, when they will enter into partnership, they have to disclose the known facts. And when they are in partnership also, it is their duty to remember that they have to disclose the facts, whatever they are doing. Some person is in charge of finance, some person in charge of market. They should not make secret profits, secret commission, all that. Now the last point is contracts of suretyship. When you are entering into giving a contract to be a surety or a guarantor for a loan, you have to disclose all the known facts because you're giving the guarantee that if the applicant is not able to pay, I will pay that. So with the surety, whoever guaranteeing that you have to give the clear information. So this is what I want to explain in this module about fraud and the contracts of UBERRIMAE FIDEI. These are all important topics from the point of view of examination also. So happy learning. Thank you.